Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Wednesday, March 25th, 2026. This is our Wednesday business agenda. I see all of the commissioners, but to follow protocol, let's take a quick roll call.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Great. Great to see everybody. I hope everybody's doing well this extraordinary spring day. We will move into our agenda. First on the agenda is commissioner comments. This is the placeholder for commissioners to be able to brief themselves, each other, and their stakeholders as to matters that are happening outside of the daily work. Anything for the calls, folks? Seeing none, we have one person that signed up for general comment. That person is Shauna Neftel. Do we see Ms. Neftel in the agenda?
Mr. Chair, we currently don't see Ms. Neftel in the attendee list. Ms. Neftel, if you're in there, would you please raise your hand and we will elevate you to speak? And in the meantime, we have elevated Jennifer Walker Graff. If we want to do the Executive Director's Office update first, I will let you know if we do locate our public commenter.
Okay, let's go ahead and knock off consent. Does anyone have questions on consent? Seeing none, all those in favor of consent signify by saying aye. Aye.
Aye. Aye.
Any opposed? That motion carries. Ms. Walker Graff, great to see you. Welcome to our Wednesday, March 25th meeting. I had that date wrong. Please, you're recognized.
Thank you, Chairman Robbins. Good morning, Commissioners. For the record, I'm Jennifer Walker Graff, Assistant Director for Energy Innovation at the Colorado Department of Natural Resources, and I'm pleased to be here on behalf of Executive Director Dan Gibbs to provide several department updates. First, I'm happy to share that Richard Fields has been named DNR's new Chief Operating Officer. Richard previously served as the department's HR Director and will be stepping into the role formerly held by Deputy Director Wendy Padilla. I also want to share that our Director of Legislative Affairs, Daphne Gervais, has moved into a new position within Colorado Parks and Wildlife. As you know, Daphne has been a vital advocate for the ECMC, and we're wishing her the best. Filling her shoes for the remainder of this legislative session is Sarah Hamming, who comes to DNR from CPW, where she served as the division's legislative analyst. We're grateful to have Sarah's expertise on board during this transition, and we'll be posting the permanent director position shortly. On a budget front, the ECMC fiscal year 2026-2027 budget is moving through the legislature. We expect the long bill to be introduced in the House next week. On the legislative front, HB 261112, our underground injection control bill, remains a DNR priority. This bill gives the state authority to regulate all UIC well classes. It's passed the House Energy and Finance Committees and is now awaiting a hearing in House Appropriations. Another notable flag for the Commission is SB 26142, which was introduced on March 19th. This bill, titled Development of Thermal Energy Resources, includes a number of provisions to encourage the development of geothermal resources, both for heat and electricity production. It also includes 2 provisions that impact ECMC. First, the bill requires ECMC to develop a voluntary geothermal data collection program. That program would enable the collection and publication of geothermal data from orphaned, marginal, and other existing oil and gas wells. The intent is that the data collected under the program would then be available to inform the regulation and development of geothermal projects across Colorado. Second, the bill requires ECMC to collaborate with other state and non-state entities to develop recommendations to inform future geothermal policy. Those recommendations would be due to the General Assembly in November of 2026. EDO has been working closely with the bill sponsors and with ECMC staff to evaluate these provisions, and we look forward to continuing engaging on this bill on your behalf. Finally, on the legislative front, congratulations to Commissioners Ackerman and Cross, as well as Orphan Well Board member Christopher Simmons, who were all unanimously confirmed by the Senate on March 16th. Thank you for your continued public service. On the waterfront, last week, Governor Polis formally activated Colorado's Drought Task Force. The task force is made up of representatives from 4 state agencies, DNR, DPS, DOLA, and CDA. Activation of the task force is prompted by record low snowpack and record high temperatures throughout the winter. With these troubling indicators of the runoff and irrigation season to come, the task force has been activated earlier in the year than ever before. The task force will meet to elevate information and impacts from the ongoing drought, coordinate potential state agency actions, and make recommendations to the governor on potential emergency drought declarations or other actions. In Parks, Wildlife, and Forestry news, CPW is finalizing its updated strategic plan. Following extensive outreach, the final version is expected to be ready this May. CPW is also hosting the Partners in the Outdoors Conference in Colorado Springs from April 27th to the 29th. Registration filled up incredibly quickly, so we encourage early signups for next year. On the forestry front, the Ponderosa Mountain Pine Beetle Task Force, which was created by the governor's recent executive order, held its first meeting in February, and their next meeting is scheduled for April 1st. In federal news, Congress is drafting appropriation bills for fiscal year 2027. While the House deadline has passed, Senators Hickenlooper and Bennett are accepting earmark requests until March 27th. Additionally, DNR continues to monitor quarterly BLM lease sales. The Q3 sale covers 31 oil and gas parcels totaling over 17,000 acres located in Jackson, Routt, Moffett, Arapahoe, Weld, Garfield, and Rio Blanco counties. The sale is currently open for public comment through April 13th, and the department will be submitting remarks to ensure wildlife habitat is protected. Finally, my last note, and perhaps the most exciting, I'm pleased to share that EPA Region 8 has notified the department that Colorado's Class 6 primacy application has officially moved into a final stage of consideration. As of Friday, March 19th, the EPA administrator has both signed the proposed rule and published our docket in the Federal Register. This publication initiates a formal 45-day public comment period that will run through May 4th. Any stakeholder may participate in this process by submitting written comments at any time during this comment window or orally at an EPA-led virtual public hearing on April 23rd from 5 p.m. to 8 p.m. Mountain Standard Time, where information related to Colorado's application will be shared. Details on how to submit comments and to register for the public hearing is posted on the ECMC website. As for timing, once the comment period closes on May 4th, the EPA will spend about 1 to 2 months processing each piece of feedback, and once they sign the final rule and publish the decision, it will become officially effective 30 days later. So this concludes my prepared remarks, and I'm happy to answer any questions that you may have.
Thank you, Ms. Walker-Graff. Very thorough, very comprehensive, and very to the point. I really appreciate the updates that we receive every so often from DNR. It helps keep us looped in with the other things that are happening within the agency under which we serve. I don't know that I've got any questions. I appreciated the call out on the EPA and also the call out for Commissioners Ackerman and Cross. I think the EPA thing is exciting just in general, and keeping the band together, so to speak, at ECMC and the Commission is a good thing for the state of Colorado. I think we're trying to do good work here. So thanks for those points. Commissioners, any questions or comments for Jennifer? Commissioner Ackerman.
Thank you, Mr. Chair, and thanks, Ms. Walker-Graff. Just a comment, and I wanted to express appreciation for Ms. Walker-Graff. She has dug in very hard since being over there at DNR and has been very helpful, certainly with me and in my role on the energy side of things. Specifically, she and I, along with Mike Rigby and the rest of ECMC's excellent geothermal team, are already addressing the potential provisions in Senate Bill 26-142, and just wanted to let you know that through the Colorado Geothermal Council and specifically the Deep Geothermal Working Group, we're certainly already brainstorming and working on potential solutions and responses to those requirements if they do indeed come to fruition.
Others with comments, questions? Great. Well, I'll let you move on into your day. Thanks for being with us this morning. We'll see you next time. All right. I am still not seeing our public commenter, and that's okay. We'll keep public comment open through the end of the day, and if she does show up, we will come back to her. So with that, we move to one of two oil and gas development plans, a WaveTech Helium Incorporated called the Diekman OGDP. It's docket 250800171. We would elevate either Ms. Jost or Ms. Wazelinski, as well as their witnesses at this point. Oh, there you are. You're up in the right-hand corner. I didn't see you.
Thank you, Chair. It looks like we're just missing two of our witnesses, which is Igor Gendelman and Patty Vogel. So if we could maybe work to find those folks, then we could start swearing in.
And if all your folks want to go ahead and visualize, that way we know they're ready, willing, and able to be sworn in. And we've got Assistant Attorney General Boudreau doing the swearing in ceremony.
Thank you, Mr. Chair. Looks like Ms. Vogel is there. Did we get Mr. Gendelman?
We did. He comes up as WaveTech Helium on Zoom, but that is
Right.
Igor Gendelman. Thank you.
Thank you. So I'll ask all the witnesses to be visualized. When I call your name, please raise your hand, state your first and last name, and swear to tell the truth. We'll start with Igor Gendelman.
My name is Igor Gendelman, and I swear to tell the truth.
Coulter Anderson.
My name is Coulter Anderson, and I swear to tell the truth.
Andrea Gross.
My name is Andrea Gross, and I swear to tell the truth.
David Bowen.
My name is David Bowen, and I swear to tell the truth.
David Ebby.
My name is David Eby, and I swear to tell the truth.
And Patty Vogel.
My name is Patty Vogel, and I swear to tell the truth.
We've got a pretty heavy echo on that one, but I got it through pretty clearly. Is that everyone, Ms. Wazelinski?
It is. Thank you.
Thank you.
And Chair, if we may, we just have a PowerPoint to bring up and then we can get started.
Yeah, that's fine. Go ahead.
Thank you. Okay, that looks great. Well, good morning, Commissioners. My name is Kelsey Wazelinski with Jost Energy Law, and with Jamie Jost, we represent WaveTech Helium in the Diekman Helium OGDP before you today in docket 250800171. We would like to thank Cheyenne County for their support of the OGDP and also ECMC staff and the director for their efforts on this OGDP. Next slide. This OGDP requests approval of an approximate 1,326.3 acre oil and gas development plan for the development of 4 new vertical wells from 4 new locations to target helium gas in the Morrow V3 and V5 sandstone. The 4 requested Form 2As are for the number 2 WaveTech Diekman 12.3 pad, the number 1 WaveTech Diekman 33.3 pad, the number 1 WaveTech Diekman 12.14 pad, and the number 2 WaveTech Diekman 13.14 pad, as shown on this map. WaveTech will utilize existing 320-acre spacing units in Section 14 to drill and develop the 12.14 and 13.14 locations in the Morrow V3 sandstone, and will utilize Rule 401 to drill and develop the 12.3 and 33.3 locations in Section 3 in WaveTech's leasehold interest in the Morrow V5 sandstone. All gas produced from the Morrow Reservoir will produce directly to the existing Ladder Creek pipeline system. WaveTech does not expect to produce oil as part of this development. The 4 proposed locations are within Cheyenne County. Cheyenne County does not regulate siting of oil and gas locations. However, WaveTech has been in close communication and consultation with Cheyenne County throughout the OGDP process and has the county's full support. The proposed locations are all within the lesser prairie chicken estimated occupied range, but are not within any connectivity area. WaveTech will discuss its consultation with CPW, CPW's waiver of ALA for all 4 locations, and how the siting and BMPs will protect this habitat in the presentation today. The Director's recommendation for approval of the OGDP contains one condition of approval regarding the submittal of reference area pictures within 12 months for the 1214 and 1314 locations, and WaveTech agrees to this COA. And finally, WaveTech has complied with all notice requirements for the OGDP. No formal petitions were filed and no public comments were received on the Form 2As. I'll now turn it over to Igor Gendelman, the Vice President of WaveTech, to continue the presentation.
Thank you, Kelsey. Good morning, Commissioners. My name is Igor Gendelman, and I'm the Vice President of WaveTech Helium. I appreciate the opportunity to present Dickman Helium OGDP. Next slide, please. Next slide. Helium is an essential element for many essential industries, and there are substantial reserves of it in southeastern Colorado. WaveTech staff has a lot of geological and operational experience and knowledge in this area, and we are leveraging it in our efforts to produce more helium. Next slide, please. 8 OGDPs have been approved by ECMC so far, 21 locations. WaveTech is actively permitting, drilling, and producing, and all the helium-containing gas is going into Ladder Creek Helium Plant gathering system, which takes it to the helium plant. Next slide. This is an overview of number 2 WaveTech Dickman 12-3 location. We plan to drill 1 conventional vertical well at this location targeting helium-containing natural gas. All the gas production will go to an already existing Ladder Creek plant through an already existing pipeline system. The proposed location is within the lesser prairie chicken estimated occupied range. All locations in this OGDP are close to a number of wind turbines, which limit any significant use of the sites by lesser prairie chickens. Nearest lake is more than 6 miles away. CPW waived ALA under Rule 304 B2 B8. Next slide, please. This is overview of number 1 WaveTech Dickman 33-3 location. This location has the same bullet points as the previous one, and the nearest lake to that location is 3.7 miles away. Next slide, please. This is an overview of the number 1 WaveTech Dickman 12-14 location. This location also has the same bullet points as the previous slides, and the nearest lake is more than 6 miles away. Next slide, please. This is an overview of the number 1 WaveTech Dickman 13-14 location. This location also has the same bullet points as the previous slides. The nearest mapped lake is nearly 4 miles away. Next slide, please. Targets for these wells are Morrow V3 and V5 reservoirs. They are fluvial channel sandstones filling incised valleys. The reservoir is highly permeable and a part of a separate gas accumulation, as shown on geology testimony cross-section. Spacing order 477-3 will be utilized to drill 2 wells to develop Morrow V3 and shallower Morrow sandstones. And Rule 401 will be utilized to drill and develop Morrow V5 sandstones. Next slide, please. This shows a permitting timeline. Next slide, please. This shows phases of operation. Pad construction will take about 4 days per location. We will drill 4 new wells. Each will not take more than 14 days. Basic production equipment will be installed if the wells are productive. All the gas will go into an already existing pipeline. Next slide, please. Next 4 slides are wildlife protection slides. All locations are within Lesser Prairie Chicken estimated occupied range. However, each location is near wind turbines, which limit any significant use of the sites by Lesser Prairie chickens. These wind turbines are shown on all the slides. All locations are far away from lakes. This particular one is 6 miles away from the nearest one. WaveTech consulted with CPW, and CPW waived the ALAs. Next slide, please. Again, wind turbines are shown here, and the nearest lake is 3.7 miles away. Next slide. Again, wind turbines, and nearest lake is 6 miles away. And next slide. Again, wind turbines, and nearest lake is 4 miles away. Next slide, please. Best management practices matching all the ones for our previous OGDPs will be used for these locations. Construction will only take place during daylight hours. The infrastructure, tanks, and other storage will be outside the 500-foot buffer from the ordinary high water mark. Berms will be utilized to control sediment migration. No uncontrolled storm water will be directed off the pad. Diversion ditches will direct storm water to sediment traps. No combustors will be used during production. All the gas will go into existing pipelines. No mud pits will be used. Next slide, please. All surface locations are on fee surface and fee minerals. The land is currently used for crops, grazing, and wind turbines. WaveTech will not use oil-based mud. No pits will be required. No permanent combustors will be used. All the gas will go to existing pipelines. CPW states that the expected noise levels are permissible, plus duration of these phases will be brief. There are no residential buildings within 1 mile of all working pad surfaces. Now I'll pass this presentation on back to Kelsey.
Thank you, Igor. Next slide, please. To summarize the Diekman Helium OGDP and WaveTech's request for approval, WaveTech cited all 4 locations to avoid, minimize, and mitigate potential adverse impacts. Again, CPW waived ALA for all 4 locations, which are in close proximity to wind turbines and far from the nearest mapped LEC locations. WaveTech agrees to the COA contained within the director's recommendation regarding reference area pictures, and no public comments or petitions were received on the Form 2As, and the director recommends approval of the OGDP. Next slide. This last slide shows the relief requested for the Diekman Helium OGDP. We respectfully request approval of the OGDP and associated Form 2As. This does conclude our presentation. So at this point, I think we can take the PowerPoint off the screen. And if everyone could please turn your cameras on, we are open for questions.
All right. Thank you for the presentation. There's a whole lot of witnesses before us, and they're sprinkled in a bunch of commissioners. So if commissioners have questions, please raise a hand, and we can get this going. All right. Seeing no questions, we move to the deliberation phase. Does any commissioner desire to initiate deliberations on this topic? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you to WaveTech for their presentation, for their continued work, particularly on the Lesser Prairie Chicken front. The Lesser Prairie Chicken, as you heard from their presentation, was really one of the primary issues that was under consideration as they were doing their work for these sites. I think this is a really good example of wildlife consultations with CPW working properly to protect wildlife. As mentioned during the presentation, These sites are in Lesser Prairie Chicken estimated occupation range, and the way that works for CPW is it sends that flag and they consult, and then they have some specific protocols that they undertake, and those protocols are if in estimated occupied range, which is not a 1202 habitat, but is a 309 just consultation trigger, then they'll survey for LECs if those areas aren't already surveyed. If they find those LECs within 2.2 miles of the proposed site, then there's a suite of additional LEC-related BMPs that are then suggested and implemented. In this case, there weren't any, the LECs were already surveyed. There weren't LECs, as Mr. Gendelman pointed out, within considerable distances of those sites. The sites are also carefully placed in areas that are already disturbed and, as mentioned in the materials, have wind-powered development already, which is a significant deterrent for lesser prairie chickens. So hypothetically, if those LECs were found, there would have been additional consultations, there would have been additional best management practices, and that would have all worked to protect lesser prairie chickens within estimated occupied range. With those not being found, the provisions that are already in the application are sufficient for their protection. And so this is, once again, in my opinion, some real benefit from the mandatory consultations associated with Senate Bill 181 that really do work to protect wildlife in Colorado and is a good example of why we have some of the best wildlife protections with regard to energy development in Colorado. That said, Mr. Chair, if there aren't any further deliberations, I would make a motion to approve this application together with the condition of approval as included in the director's recommendation and articulated by the applicant.
Second.
Thank you very much, Commissioner Ackerman. I appreciate you leading off. I think that was appropriate. I'm in agreement with everything you said. We have a motion and then we have a second from Commissioner Messner. Is there further deliberation on the motion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? That motion carries and docket 250800171 is approved. Thank you. Let's take 10 and come back at 9:38. And in the interim, let's tee up the next docket for consideration by the commission. All right, welcome back. Good morning, Ms. Jost. We are taking up this docket.
Volume up here.
Docket 250500076, the GMT Exploration Company Gorge OGDP. If you want to elevate your witnesses, we'll start with swearing them in.
Yes, thank you, Chair. If everyone from GMT could come on screen, so that would be Hans and Tom, if you could come on. And we do have Brad Davis with Tom Loveland in the room too.
So Brad Davis, it was actually his testimony, so it's Brad Davis with Tom Loveland in the room.
Okay, sounds great. All right, Chair, we have everyone elevated. Thank you.
Go ahead, AG Bedra.
Thank you. Ms. Jost, I have a list of, what is it, looks like 7 people here. Are you saying we only need to swear in Hans, Tom, and Brad?
So we need to swear in Max Flair, Andrea Gross, Hans Schuster. We are going to swear in both Tom Loveland and Brad Davis, BJ Cox, and Randy Frederick.
Okay.
We'll swear everyone in, and we have 2 main panelists.
Okay, thank you.
Yeah.
So I'll ask all the witnesses to be visualized. When I call your name, please raise your hand. State your first and last name and swear to tell the truth. Max Blair. You're muted, Mr. Blair.
My name is Max Blair. I swear to tell the truth.
Andrea Gross.
My name is Andrea Gross, and I swear to tell the truth.
Hans Schuster.
My name is Hans Schuster. I swear to tell the truth.
Tom Loveland.
My name is Tom Loveland. I swear to tell the truth.
Brad Davis.
My name is Brad Davis. I swear to tell the truth.
BJ Cox.
BJ Cox. I swear to tell the truth.
Randy Frederick. We could not hear you, Mr. Frederick. All right, good.
How about now? Can you hear me now?
Yep.
All right. My name is Randy Frederick, and I swear to tell the truth.
Thank you. Did I get everyone, Ms. Jost? You're muted, but I think I read your lips to
You
say
did.
yes.
Thank you. Sorry, because we're all on mute this morning.
Go ahead, Ms. Jost.
Wonderful. Thank you so much, Chair. Well, if all of our panelists can go off screen for now, then we will pull Mr. Blair and Ms. Gross up as we progress. Let me go ahead and share my screen. Chair, are you seeing the full presentation?
Yep.
Wonderful. All right. Well, good morning, commissioners, council, staff, and the listening public. My name is Jamie Jost of Jost Energy Law, and along with my partner, Kelsey Wazelinski, we represent GMT Exploration in the Gorge OGDP application before you today in docket 2505-00076. We would like to thank the ECMC staff and the director for their efforts on this OGDP, as well as Arapahoe County for their continuing efforts and dedication on processing GMT's local permit to administrative approval. We'd also like to thank the Colorado State Land Board for their coordination in citing the two proposed locations on state surface, and CPW and CDPHE for their continual communications with GMT on this project. We also appreciate the commissioner question we received prior to hearing, and we will address that during our presentation today. I would like to start by summarizing the Gorge OGDP application and the requested relief before I turn it over to Mr. Max Blair, Regulatory Manager of GMT, and Andrea Gross, owner of Upstream Petroleum. The Gorge OGDP was filed on May 2nd, 2025, and the OGDP requests that the Commission approve the approximate 6,394.8 acre Gorge OGDP for the development of up to 24 horizontal wells, to establish an approximate 6,394.8 acre drilling and spacing unit for up to 24 horizontal wells, 12 on each pad, within the unit for development and operation of the Niobrara Formation from 2 new surface locations within the proposed unit, and also to approve the Form 2As for the North Rim and Black Canyon pads. The Gorge OGDP is located within Arapahoe County as the relevant local government, and both locations are awaiting final approval. However, GMT is confident that such final approval is forthcoming in the very near future. There are no proximate local governments for these locations. This OGDP triggers only one Rule 304 ALA criteria for high priority habitat, and GMT worked very closely with CPW on the 2 proposed locations. As part of this coordination with CPW, GMT is committed to conducting pre-production operations outside of the HPH timing restrictions. The 2 proposed locations are over 2,000 feet from residential building units, high occupancy building units, school facilities, and childcare centers, and are also outside of the 3,000-foot Arapahoe County 2023 setbacks. The proposed North Rim location is located in a disproportionately impacted community. However, the closest RBU is over 1 mile from the working pad surface, so no ALA criteria applied, and Rule 604B4B also does not apply. The proposed Back Canyon location is also located within a disproportionately impacted community. However, the closest RBU is approximately 3,142 feet from the working pad surface, so no ALA criteria applied, and Rule 604B4B also does not apply. As part of the Gorge OGDP, GMT has firmly committed to several BMPs that will serve to avoid, minimize, and mitigate potential adverse impacts. Some of these BMPs include, but are not limited to, the avoidance of RBUs and high occupancy building units within 3,000 feet of the working pad surface, avoidance of any public water supply, siting the 2 pads on undeveloped rural Colorado State Land Board surface lands, intentionally siting the 2 pads outside of mule deer high priority habitat, committing to conducting all pre-production operations outside of timing stipulations for pronghorn winter range that run from January 1st to April 30th, or 120 days out of the year, utilizing Tier 4 or equivalent drilling rig for the first occupation at the North Rim pad, and then fully committing to an electric rig for the second occupation at the North Rim pad, as well as both occupations at the Black Canyon pad. Oil and gas takeaway will be in place from the date of first production. GMT will use Group 3 drilling mud and it will also install 2 water quality monitoring wells at each pad and will conduct sampling of the wells throughout the life of the project. GMT has complied with all notice requirements for the Gorge OGDP. No formal petitions were filed, and 1 public comment was submitted in support of the application. GMT obtained a director's recommendation for conditional approval of the Gorge OGDP, and GMT firmly commits to each of the 5 conditions of approval relating to the Rule 502 interim reclamation variance submitted with this OGDP application. GMT respectfully requests that the Commission approve the Gorge OGDP application, the corresponding drilling and spacing unit application, as well as the variance application, and the 2 Form 2As. GMT is in compliance with all applicable rules and looks forward to presenting this approvable application to you this morning. With that, I'd like to turn it over to Mr. Max Blair, again, Regulatory Manager for GMT, to continue the presentation.
Good morning, Commissioners. I'm Max Blair, the Regulatory Manager for GMT. Along with Andrea Gross from Upstream Petroleum, we appreciate the opportunity to present this Gorge OGDP today. GMT will present a variety of topics regarding the Gorge OGDP, and we seek your approval for this application today. We have appreciated working with the ECMC staff, Arapahoe County, the Colorado State Land Board, CPW, and CDPHE on this OGDP application, and we look forward to continued collaboration as our development progresses. I'd like to introduce the GMT team. GMT is a privately held independent oil and natural gas company operating here in the DJ Basin. Primarily, we're in the city of Aurora, Arapahoe County, and Elbert County. As of the date of this hearing, we operate 15 wells in Arapahoe and Elbert, and we look forward to developing the Gorge OGDP as soon proposed in this application. I'm going to take you through a timeline, an overview of the OGDP permitting process and our development plans. We're eager to start development on the Gorge OGDP, the North Rim and the Black Canyon locations within the OGDP lands. As shown on this slide, GMT engaged in pre-application discussions with the ECMC and Arapahoe County prior to filing the OGDP on May 2nd, 2025, and the required 7-day completeness notice letter and notice of hearing were mailed by our council. We received a director's recommendation for conditional approval, and GMT agrees with the conditions of approval provided in that recommendation. The OGDP received no public comments within the 30-day public comment period, and we received 1 public comment in support to this hearing, and there were no Rule 507 petitions filed. This slide takes you through some additional planning, permitting, and consultation dates relevant to this OGDP. We engaged in multiple consultations with various stakeholders. I won't cover every item on this slide, but I do believe it helps illustrate the process we followed while planning this project. We engaged with Arapahoe County, the Colorado State Land Board, and CPW early in this process to ensure that we accounted for all of the biological, cultural, and hydrologic resources that might be affected. We took a proactive approach with Xcel Energy to provide as much lead time as possible for electrical infrastructure to be evaluated. And I just like to say I'm really grateful for the time that members of staff at the county, CPWs, Colorado State Land Board staff, and Xcel have all committed to evaluating this project and assisting us in our planning efforts. So now we're going to cover a series of slides. The next 10 or so will cover the details of the North Rim pad, and then we'll move on to the Black Canyon pad. The North Rim is located within pronghorn winter concentration area high priority habitat. That's illustrated by the red hatching on this air photo. The pad sits on largely undeveloped land. It's currently used for grazing and has been used historically for oil and gas development as well. And then there are several slides that will follow, providing additional details of our ALA, alternative location analysis. And this was included in the ALA submitted to ECMC staff as part of the OGDP. This map was developed internally early in the process for planning, and I believe it helps illustrate some of our early planning work and the initial siting efforts. There's a lot of information on this map, so I'll try to cover just some highlights. The proposed North Rim pad is shown in a yellow box, and the three black boxes represent viable alternatives that were evaluated as part of the ALA. There's blue dash lines running vertically through the map. The dash line to the west of the pad represents a 3,000-foot setback from future proposed Reservoir C on the State Land Board. There's a blue dash line to the east of the pad. That's a 1 mile buffer from the same reservoir. The reservoir can be seen here on the left edge of the map in a red hatch coloring. There are a number of blue, green, and purple buffers illustrated on this map that all represent various water resources. And there's a green hatch shading for mule deer habitat, which we were able to avoid with our proposed location. Lastly, I'll point out that there's some information here around the Colorado State Land Board tier mapping system. And I'd like to clarify that GMT's lease and SUA are not subject to that tier map. However, we're well aware of the establishment of that system as a planning tool for the State Land Board, and it is used for some other contracts they have. So we worked with the Colorado State Land Board to respect the principles behind the development of that tool, and we were able to avoid impacts to any tier 1 lands, which are the essentially the highest value lands, and generally coincide with hydrologic resources, floodplains, and riparian areas, things like that. This next map, I'll point out it's quite dense. There's a lot of information included here. It was part of our ALA submitted to the ECMC. It's a smaller scale, so we're showing a larger mineral development area from the North Rim, the minerals that will be accessed from the North Rim pad. We are, one element that's missing here is that 3,000-foot buffer from the reservoir, but the reservoir itself is shown on the map. And then you can also see the nearest RBUs to the North Rim pad are all over a mile away, and they lie to the east of this pad. This ALA map focuses primarily on water resources, so it's just a subset of the criteria included in the previous map. This ALA map provides information about existing oil and gas developments and the RBUs, again, shown to the east. And then map number 4 here is focused on high priority habitat layers. You can see the mule deer winter concentration area in red to the east of the pad. And then another red hatch that underlies the pad is pronghorn winter concentration area. The pronghorn HPH layer is quite large, and it covers the entire drilling and spacing unit. We were not able to identify any alternatives that would avoid pronghorn HPH to develop these minerals. So now we'll move into individual site maps, and I'll move through this fairly quickly. Our proposed site was selected for many of the reasons you can see listed on this slide, and I'll note that it does meet all of GMT's internal requirements for development. That would include topography, geology, engineering, and development and operational criteria. This map shows location of alternative 1, and it was dismissed due to impacts on hydrologic resources. Alternative 2 was also dismissed due to the proximity to hydrologic resources. And alternative 3 would have had an impact on mule deer HPH. among other things. So that covers North Rim. Now we'll discuss Black Canyon, and we'll be looking at the same set of images for specific to the Black Canyon location. This is located in Pronghorn Winter Concentration Area, and the nearest RBU to the Black Canyon pad is 3,142 feet away. While the Black Canyon pad is located in Arapahoe County, which is within a DI community, the nearest RBU is located in Elbert County, which is not designated as a DI community. And that RBU is to the south and west of the pad. I'll note that this also sits on Colorado State Land Board property. It's largely undeveloped, currently used for grazing and some historic oil and gas development. There is a oil and gas site visible in this image to the south. That's the Ragged Pad operated by GMT, and that's located in Elbert County. And again, the next several slides are going to cover details of our ALA. So we'll start with our planning map that we developed when siting these locations. Again, there are numerous resources and represented by various polygons here. The proposed pad is shown in yellow. The 3 black boxes are alternatives that were evaluated. The proposed reservoir C is shown in the upper left of the map. Blue dashed lines represent 3,000 foot and 1 mile buffers from that reservoir. Blue, green, and purple buffers are generally for water resources. There's mule deer HPH zone shown in green to the east of the pad, which we are avoiding with this proposed location. And the Colorado State Land Board tier map is shown. And once again, I'll note that we were able to avoid tier 1 lands with the siting of this project. There is one other buffer represented here, which is the purple dashed line, and that represents a 3,000 foot setback from existing RBUs. And that 3,000 foot setback is from the Arapahoe County Land Development Code, since these locations are sited in Arapahoe County. This first map, again, very dense, included in our ALA, a little bit smaller scale and a wider view. You can see there are significantly more RBUs down in Elbert County outside of the State Land Board properties. And I want to reiterate that the nearest RBU to this proposed site is 3,142 feet to the south and west of the proposed pad. This map focuses primarily on water resources, and proposed reservoir C can be seen to the north and west of the proposed pad. This map illustrates existing RBUs and existing oil and gas sites. And lastly, we're seeing here high priority habitat layers. And I'll note that the Black Canyon pad is within pronghorn HPH, but does avoid mule deer HPH. And again, the pronghorn HPH layer essentially covers the entire mineral development area. I do want to point out a typo on this slide. I do apologize, but the first bullet lists it as greater than 5,280 feet. That's incorrect. It is 3,142 feet from the nearest RBU. So I apologize for that mistake. The rest of the information on this slide is correct. And we selected this for the reasons shown on the slide. Alternative number 1 was dismissed primarily due to its proximity to hydrologic resources. Alternative number 2 is closer to hydrologic resources and also sits within mule deer high priority habitat. And lastly, alternative 3 is co-located with GMT's existing Ragged Pad. This location is closer to existing RBUs. It's closer to mapped hydrologic resources. It sits within mule deer HPH, which was established after the Ragged Pad was developed. And it sits outside of the proposed mineral development area, which would have made this an off-lease location. That would have required a new surface use agreement with the property owner, and they were not willing to entertain that opportunity. Now we'll move on to some details around our engagement with Arapahoe County. We held our pre-application meeting on January 1st of 2025. We posted public notice signs on March 17th of 2025. You can see a photo of those there. So anyone driving past these proposed locations would have been provided information from those signs on how to engage in the planning process here. We held a community meeting on April 4th. We sent out notifications per the Arapahoe County LDC requirements. Their notification radius for projects like this is a 1.5-mile radius. We actually expanded that a little bit further to ensure we captured some neighbors, primarily to the east. We didn't want to send letters to just one neighbor in a subdivision, so we expanded slightly to include a few more folks. We mailed 56 letters. We had about 8 people attend. I say about because I know we had a few folks sharing computer, so we don't have an exact count of how many people were in the room, but we believe there were about 8. We had a number of follow-up meetings with neighbors after that meeting and discussed some of our existing operations in Elbert County and entertained questions. We submitted formally to Arapahoe County for our permit on June 17th of 2025. And as of today, I can state that both pads are compliant with all of Arapahoe County's 3,000-foot siting setback requirements. The permits are progressing for a formal administrative approval. We do anticipate that approval coming very soon. And I'll state that GMT acknowledges that we cannot construct or develop either the North Rim or the Black Canyon location without formal administrative approval from Arapahoe County, and we do not plan to do so. Now I'd like to cover some phases of operation. Again, I apologize, there is one minor typo I'd like to call out. On the Black Canyon completions date, the first date should read third quarter of 2028, not third quarter of 2026. I do apologize for that typo. If GMT were to receive approval today of this OGDP, we plan to submit the corresponding Form 2s for the North Rim and commence construction in the second quarter of 2026. Once we receive approval of the Form 2 North Rim location, we'll start drilling operations in second quarter of 2026, and completions also planning to take place in the second quarter of 2026. First production anticipated sometime in the third quarter of 26. We plan to drill 6 wells with the first drilling rig occupation on the North Rim, and the remaining development schedule shown here with subsequent drilling occupations planned for both North Rim and Black Canyon. All of these operations are planned to take place outside of pronghorn HPH season to avoid impacts to that wildlife resource. I'd like to acknowledge that we received a question in advance from the commissioners, so thank you very much for providing that. It's very helpful. And the question was around the 4-year timeline to develop these 24 wells, recognizing that there are wildlife stipulations. So our response to that question is that GMT's long-term development plans require that we must carefully balance high priority habitat restrictions, our lease commitments, future infrastructure needs, and the timing for build out of that infrastructure, and limited capital. To make this work, our plan calls for reoccupying these 2 locations as shown. And now I'd like to turn it over to Ms. Gross to discuss cumulative impact analysis and BMPs.
Thank you, Max. Good morning, Commissioners. My name is Andrea Gross, and I'm the President of Upstream Petroleum Management. In the next slides, I will go over GMT's cumulative impacts and then highlighting some of the BMPs that GMT committed to through the CDPHE consultation process. This slide summarizes how the Gorge OGDP addresses cumulative impacts through the ECMC hierarchy of avoidance, minimization, and mitigation. The goal of avoidance measures is to eliminate the risk or impact. Minimization is to reduce the likelihood or severity of that impact. And mitigation is to offset or compensate for that impact. First, avoidance. Both the North Rim and Black Canyon locations are sited outside of 2,000 feet from any residential building unit or high occupancy building unit, and over 1 mile from any school or childcare facilities. While both locations are within a DI community, they are 3,000 feet from any RBU. They're also outside of any public water supply area or designated outside activity area. As Max already said, they are located on undeveloped Colorado State Land Board surface, which avoids many of the setbacks, as well as they're exceeding both ECMC and Arapahoe County setback requirements. Next is minimization. GMT will use a Tier 4 or equivalent drilling rig for the first occupation on North Rim, and then electric drill rigs for any subsequent operations on both locations. They will have gas pipeline takeaway prior to production. They will use a Tier 4 quiet completions frac fleet. They will have electrified production facilities after production. They will use Group 3 drilling mud. They will use an MLVT to reduce truck traffic and use pipeline for fresh water for completions straight to the location. Per Arapahoe County, 2 water quality monitoring wells will be installed at each location, where they will be sampled throughout the life of the well. The sites will be remotely monitored 24/7. Finally, mitigation measures include continuous noise monitoring, as well as baseline and ongoing air monitoring. They'll use PVT alarms and automation and other sensory monitoring devices. They'll have motion-activated lighting, regular inspections, and wildlife protections, including avoiding pre-production operations during the pronghorn winter concentration period. Together, these measures demonstrate that GMT has comprehensively addressed cumulative impacts with compliance with ECMC rules. GMT consulted with CDPHE on January 20th, 2026, and has applied a majority of the CDPHE requested BMPs. On these slides, we will describe a couple of additional slides or additional BMPs that were already mentioned on slide 29. These commitments include the use of MLVTs with secondary containment beyond regulatory regulations, reducing the use of natural gas burners for production equipment where feasible, as well as GMT is also committed to providing access to agencies for air monitoring equipment, and they will actively collaborate with both ECMC and CDPHE in the event that emissions are observed. The first occupation at North Rim will utilize a Tier 4 rig with electric rig plans for all subsequent occupations. These commitments reflect GMT's proactive approach to emissions reduction and regulatory coordination. In addition to the commitments already discussed, GMT has agreed to several other operational practices designed to further protect air quality and promote transparency. Vehicles and equipment will be properly maintained, and service providers will be used that have models of 2010 or newer, with non-road equipment meeting EPA Tier 4 final standards. On high ozone forecasted days, GMT will postpone construction activities where practicable, and they will delay flowback if emissions cannot be adequately captured. GMT will maintain a publicly accessible digital information source, as well as GMT will hold an information session after approval and prior to drilling to provide nearby residents an overview of anticipated activities, schedules, and impacts. These slides show the additional CDPHE BMPs that GMT has committed to avoid, minimize, and mitigate potential adverse impacts from this OGDP development. And now I will return it back to Ms. Jiss. Thank you.
Wonderful. Thank you, Ms. Gross. After a thorough review, analysis, and evaluation, of the Gorge OGDP, the North Rim Form 2A, and the Black Canyon Form 2A, as well as the proposed drilling and spacing unit, the director issued a robust and thoughtful director's recommendation that recommended conditional approval of the application with 5 conditions of approval attached to the requested Rule 502 variance. GMT greatly appreciates the staff and director's time and communication with GMT on the variance request and fully agrees to each condition of approval outlined in the director's recommendation. The director's recommendation expressly provides that the Gorge OGDP complies with all applicable requirements of the commission's rules and recommends conditional approval by the commission. I will now take a few quick minutes to describe the sworn Rule 505 testimony submitted in support of the OGDP and spacing applications. The spacing application submitted with the OGDP application requests to establish an approximate 6,394.8 acre drilling and spacing unit for the development and operation of 24 horizontal wells in the Niobrara Formation. GMT has a majority leasehold interest in the proposed drilling and spacing unit, and the mineral development area is owned in fee and by the Colorado State Land Board. Since Colorado State Land Board minerals will be produced, a communitization agreement will be required, and GMT will execute that with the State Land Board. In addition, ECMC staff indicated in the director recommendation that staff appreciates the utilization of a single large DSU for these application lands, thus eliminating the need for multiple individual wellbore spacing units and additional pads. GMT also submitted detailed geologic testimony and exhibits to support the OGDP and spacing applications. The geology exhibits show that the Niobrara Formation is present throughout the application lands, is an approximately 310 to 360 feet thick, and is both a hydrocarbon source rock and a reservoir. Finally, GMT submitted detailed engineering testimony and exhibits to support the OGDP and spacing applications. The proposed drilling and spacing unit is sufficient to be efficiently and economically drained by 24 horizontal wells in the Niobrara Formation, and the average drainage radius will not extend beyond the requested subsurface setbacks, thus preventing waste and protecting correlative rights while remaining economical. GMT seeks a Rule 502B variance for relief from the interim reclamation timing requirements in Rule 1003B for both the North Rim pad and the Black Canyon pad. The variance is requested by GMT and is supported by the Colorado State Land Board to avoid unnecessary harm to the surface when GMT proposes 2 occupations at each location. GMT accepts and supports the 5 conditions of approval in the director's recommendation relating to the delayed interim reclamation period, which is not to exceed 36 months from the commencement of construction of the North Rim pad and the Black Canyon pad. So to summarize, the Gorge OGDP and GMT's request for approval, we note the following OGDP highlights. There's no RBUs within a disproportionately impacted community within 2,000 feet from the locations. There's no RBUs, high occupancy building units, schools, or childcare centers within 2,000 feet from the locations, or even 3,000 feet. GMT will conduct all pre-production activities outside of the HPH timing stipulations from January 1st through April 30th of each year. There were no Rule 507 petitions filed, and the Arapahoe County administrative permit is progressing nicely to an anticipated administrative approval in the near future. The Gorge OGDP provides substantial protections of public health, safety, welfare, the environment, and wildlife resources by siting outside of sensitive receptors, and the best management practices avoid, minimize, and mitigate potential adverse impacts. And finally, the director's recommendation does recommend approval of the OGDP and concluded that ECMC staff does not anticipate any significant potential direct adverse impacts to public health, safety, welfare, the environment, and wildlife resources. This slide shows the requested relief for the Gorge OGDP, and we respectfully request approval of the OGDP, the associated drilling and spacing unit, as well as the 2 Form 2As. We thank you for your consideration of this application today. And with that, I will go ahead and pull the slide down and ask the rest of the panelists to come on video for any commissioner questions.
All right, thank you very much. Appreciate the thorough analysis presented this morning. Commissioners, we have a panel before us open for questions. Commissioner Cross?
Thank you, Mr. Chair. Thank you for this presentation. I do want to ask a couple questions, and while that wasn't my question ahead of time, I did want to go into this 4-year timeline and multiple occupations on each. So one of the first things that stuck out to me, Mr. Blair, when you talked about that, is one of the reasons for the multiple occupations you gave was limited capital. Could you go into a little more detail on that?
Yes, Commissioner Cross, thank you for the question. As I believe you follow oil markets and price just as we do, but we have to manage our capital as we develop these sites. Drilling horizontal wells in the Niobrara is quite expensive, and our plan allows us to manage that capital and generate production and cash flow from operations. So that was a factor in developing this schedule.
And where would you put that as a factor compared to some of the other reasons that you listed?
That's a great question. I'm not sure we have a ranking of that, but I'd say it's among the top priorities for us to ensure that we are spending cash and generating revenue responsibly for our investors and for our cash flow and business model.
Okay. With respect to the slide that you had there, I think there was a typo as well. One of the completions being, I think it said second quarter 26 and third quarter 28 for one of them. So I just wanted to confirm that was supposed to be 28 for both.
Yes, I do apologize for that. We read these slides multiple times to prepare for these hearings, and that was just a typo. So, of course, we're not going to have the ability to complete those wells until they're drilled. So we're not going to, I think I did state the correction that it would be 2028, not 2026 for the Black Canyon.
Okay. And one of the other things that I wanted to touch on with respect to, as you're kind of looking at the multiple occupations, obviously one of the things I appreciate is the working with CPW and making sure you're outside the timing limitations that are provided there. But obviously one of the things that we have to deal with as well is a lot of times when you go outside these timing limitations, you're also going into ozone season. And so in looking at some of the issues or some of the best management practices that you're using, one of the things you mentioned was electric production depending on the utility timing. Can you provide us a little bit more detail on where you are with respect to the utility timing and where that is?
Yes, thank you for that question, and I'm happy to elaborate there. So we've requested that power from Xcel Energy. They have this is within their territory, and we've been working with them, as I mentioned, for over roughly 2 years on this project. We started our discussions with Xcel before filing, having final siting of these locations and filing with ECMC. So we started as early as we could. The power we've requested is adequate to support production operations and grid power drilling as well. So once it is constructed, we'll have all the power we need for these operations. As far as status goes, we have final design from Xcel. Quite a bit of infrastructure needs to be built, roughly 5.3 miles of new distribution line, and I believe also some upgrades to the substation that we're pulling from. So we've paid the full amount of the cost of that improvement, but the timing of construction is Xcel's, that's outside of our control. So as soon as that power is available, we will tie into it and utilize it.
And so are you requesting, at least for now, non-electric production equipment until you can make sure that you get the electric production?
Yeah, our facilities are designed to run on electricity. The source of that electricity in areas where no infrastructure is available would be a natural gas powered generator, and we have used those on other sites in Elbert County. So if we have clear indication Xcel has begun construction and will be ready for the time we turn facilities on, we'll tie into that grid power. If we believe it will be sometime after we're ready to bring on production, we'll use a temporary generator to power our production facilities and replace that generator once grid power is available.
Okay. And then, so I'm understanding correctly, what the first occupation, I can't remember which one it's for, the North Rim.
North Rim and this coming up very shortly. We're hoping to begin once Pronghorn HPH restrictions lift.
Okay. And so that one will be done not on electric drilling for the first occupation.
That is correct. Excel has not yet begun construction, and we are confident that they will not have grid power there in time to meet our needs. So we have committed to using a Tier 4 or equivalent rig under the CDPHE guidelines, and that's been reviewed and was part of the CDP consultation, and also our discussion with ECMC staff, and it's included in the director's recommendation. I think we also provided some additional information in there around our work with Excel. We are committing to using grid powered drilling for all future drilling occupations. So once we have established production within this drilling and spacing unit, we recognize the importance of minimizing our impacts and emissions from these operations, and we're committing to using a grid powered rig for all future occupations. And the timing of that, again, is unknown, and primarily Excel's responsibility to meet that request that we have paid for, but we have no control over that timing.
Okay. And kind of tying that back into my initial question as well, was there any consideration with respect to the multiple occupations to potentially start under the given timeline with the other pad that you're discussing and not do the North Rim until electric drilling would be a possibility?
I appreciate the question, and our contractual obligations to develop are looming, and we simply must get work started this year. In fact, in the second quarter of 2026, in order to meet those contractual obligations. As you can see from our presentation, we have been planning this site and working as proactively as possible, but we are running up against a deadline contractually, and that's why we've chosen to utilize a Tier 4 or equivalent rig for this first drilling occupation.
Okay, so it's with respect to the leases that you have there, which
correct.
Is really
it's a sizable drilling and spacing unit. There's a number of leases included in it, and we have obligations we have to meet.
Okay. I think those are my only questions for now. And just so everyone's aware, my internet kind of keeps going in and out a little bit. So I'm going to be on, but I'm going to turn off my video here just to make sure that it stops getting all crinkly on me.
Great. Thank you, Commissioner Cross. Others with questions? Commissioner Ackerman.
Thank you, Mr. Chair, and thank you to Commissioner Cross for his initial questions as well. I just want to say I appreciate the work on this application. These applications are a lot of work. The operators work very diligently to ensure all of the T's are crossed and the I's are dotted, along with their counsel, and I really appreciate the significant work here. I recognize that there are many threads that each operator needs to pull on simultaneously as they're putting these lengthy and complex applications together. My concern also, though, is along the timeline here, and the director's recommendation as well as the presentation today talked about 2 occupations for each location that essentially begin in Q2 of 2026 and finish in Q4 of 2029. That's just under 4 years, which is a very lengthy timeline for what we're accustomed to for 24 wells. I do appreciate some of the explanation today. And my understanding is that the North Rim construction would take place Q2 of 2026, drilling Q2 of 2026, and completions Q2 of 2026. But then there would be a second occupation of that site in 2029, again, drilling completions with interim reclamation to follow in 2030. Similarly, on Black Canyon, construction of Q2 on 2028, drilling Q2 of 2028, completions Q2 of 2028, and then coming back in 2029, Q3 and Q4. That's 4 total occupations, not including reclamation. I think arguably that's 3 occupations, as you can maybe argue that activities in 2029 are moving drilling operations and completion operations maybe directly from North Rim over to Black Canyon, but still stretching from Q2 2026 to Q4 2029. My major concern here is that the wildlife consultation summary is written on an entirely different basis, as far as I can tell. It's written on the basis that there will be 2 overall occupations, occupation 1 from Q2 to Q3 of 2026, and then occupation 2 from Q2 of 2027 to Q3 of 2027, which would be more commensurate with what we usually see and with what CPW usually approves with this number of wells. So my concern is that if the director's recommendation on the timeline in your presentation today is correct, I don't have any verification that CPW worked under that same understanding. From their consultation, they stated, as discussed in tables 1 and 2 below, the operator is planning to develop up to 24 new wells, 12 in each location, with this number of truck trips across both locations within HPH. This work is estimated to start in May through September 26 and pause before resuming in May through September 2027 to avoid both HPH seasons. They also state for both locations within 1202D HPH, CPW Northeast generally recommends that all 3 phases of new operations occur outside the wintering season, particularly for high intensity activities, which certainly you're working hard to do, and I appreciate that, which this operator is proposing by using 2 occupations, 1 non-winter pre-production work per location for 2 consecutive non-winters. So their understanding appears to be that you're doing your first occupation in 2026 in the summertime, and then coming back in 2027, which isn't mentioned 2027 anywhere in the director's recommendation or your presentation today. And so I just wanted to bring that up and ask you to adjust or to address that discrepancy and help me understand, number 1, if you know why it's the case, and number 2, update me on any updated discussions with CPW that aren't reflected in the materials that we have.
Yeah, Commissioner Ackman, thank you so much, and I appreciate you reviewing that consultation so carefully. I believe that discrepancy might be due to timing of those initial discussions with CPW and some adjustments that we made to the schedule throughout this planning process over a period of 2 years. So I think the clear takeaway, and I do agree there, I do see some discrepancies now. I'm looking at the final letter from CPW and the final consultation, and there are some mismatched dates. But the clear takeaway is that CPW is aware we would have multiple occupations on each of the 2 pad sites. They were grateful and appreciative, and they are aware that we plan to perform those operations outside of Pronghorn HPH to avoid those impacts. And the timing of the year in which those take place, again, I'll acknowledge there's a mismatch in that consultation and the slide deck and our current schedule. But I think the impacts, it's hard for me to imagine how those impacts might be different. I don't think the Pronghorn have an annual calendar that they reference, but our plan is to avoid impacts by respecting those HPH timing restrictions.
Thank you, Mr. Blair, for that response. And then just to follow up, was that discrepancy understood by the company and further discussions had with CPW, or do they remain under the assumption that this is taking place on an entirely different time frame?
I can't speak for CPW, certainly. I have been in touch with Brandon Moret as recently as yesterday, discussing the timing of this hearing. I know Brandon is fully aware of the date of this hearing, and we've been coordinating our plans to finalize our work with them regarding the compensatory mitigation payments that we've committed to. And Brandon is expecting that payment prior to the start of work for this season. So I am more than happy to meet with CPW after this OGDP hearing, communicate these changes that were presented today, and discuss our plans and ensure that there aren't any concerns. But I don't imagine that there would be concerns from them regarding the year, provided we stick to the principle of avoiding winter concentration seasonal restrictions.
Thank you for that response and for that commitment, Mr. Blair. I certainly understand how things like this can happen over a long time frame of planning. That said, it does cause me difficulty. I don't see CPW's Northeast representatives on the call today. It does put me in a bit of a conundrum, knowing that their understanding is different than what's been presented here without verification from them. And so I do think, certainly follow-up is warranted. I think your assumptions are probably pretty sound from a wildlife protection standpoint. The most important thing to them is that you're doing these things outside of winter timing stipulations. I would agree with you there. I know that CPW also has concerns about multiple occupations as well, and it's hard for me to make assumptions as to what their stance would be on these multiple occupations. So it does put me in a difficult position for approval today without some verification from CPW or some kind of assurance that we can make sure that's worked out going forward.
I do understand your concern, and as I stated, I'm more than happy to discuss with CPW. I do intend to meet with CPW after this hearing. And our concern, our primary concern, would be to have the ability to develop North Rim this season immediately. So we are in need of ECMC approval today, if possible, so that we can proceed with these plans and not miss this season and our ability to develop and meet our contractual obligations. So. While I do appreciate your concerns on this, again, I'll just reiterate that the principles discussed with CPW are reflected in our commitments to timing and the schedule we proposed. As I've acknowledged, it has changed a bit over the 2 years of planning here, but the essential components are the same, that we're committing to performing this work outside of those HPH restrictions.
Thank you, Matt. Mr. Ackerman, I'm so sorry to jump in. Mr. Gross would like to add something as well to help on this, and then I'll add something at the end too, if I may, Chair and Commissioner.
Yes,
Go ahead.
So I was able to find an email. I had remembered we had some email correspondence with Brandon before he sent that final CPW summary. And on February 5th, we gave him the schedule that was shown in this PowerPoint presentation. So I do believe that Brandon knows about the multiple occupations. I apologize for not catching that when we got Brandon's final summary. We should have caught that and asked him to update it with the schedule. But I do have an email correspondence back and forth between GMT, myself, and Brandon, where he is aware of the proposed schedule. I'm happy to provide that to you guys.
Thank you, Ms. Gross. I appreciate you bringing that up. And now you mentioned an email that you sent there and also correspondence. Do you have an email response from Mr. Moret acknowledging your email as well?
I do. I mean, it's short and sweet. On February 6th, it is thanks for this update. And right after that, he sent out the summary a couple days later. So he did acknowledge it. He didn't bring up any additional concerns with that proposed schedule with the multiple occupations. And that was really the last we corresponded with Brandon.
Thank you, Ms. Gross. And Mr. Chair and Ms. Gross, if you're amenable to it, can you give me the context of what your email to him was on that day?
Yeah. So Brandon always, actually not just Brandon, all the CPW representatives that we work with, before they send their final consultation summary, there's usually a couple last minute questions, some clarification questions, one of which is scheduling, because many times our initial consultation with CPW is, 6 months prior. He always likes to get a finalized or more realistic timeline. He also sends us an email confirming that the BMPs have not changed, that the operator is still amenable to those CPW BMPs. So we always confirm those as well as scheduling.
Thank you, Ms. Gross. And specifically what I'm looking for is in your email to him that he responded to, do you specifically set forth this timeline as has been presented in the director's recommendation and the presentation today?
Yes, we do. And ECMC staff was also on those emails. So it should be of record in the documents or available.
Thanks for that addition, Ms. Gross. I appreciate that.
Mr. Chair, thank you so much. So Commissioner Ackerman, and this also goes to Commissioner Cross's question. I just want to point out that 2 occupations are increasingly common in the DJ for numerous reasons. In this instance, you have an operator who has taken many, many steps to avoid, minimize, and mitigate, specifically avoid. We are in an area where there are no RBUs within 3,000 feet. They have committed to using Tier 4 drilling rigs for 1 occupation, those electric rigs for the 3, even though that might be spread out, and it's actually over 3.5 years. So I guess I just want to make sure that we're all understanding that GMT has taken many, many steps to avoid adverse impacts to public health, safety, welfare, environment, specifically the wildlife resources. And when you take into account not conducting pre-production operations for 120 days in each of those years, that takes out a third of a year. And so I just want to make sure that, this commission is aware that 2 occupations are not uncommon, especially in areas where we do not have human receptors. And we have support from Arapahoe County for proceeding to the final administrative approval of these, state land board, as well as other stakeholders. So I just kind of wanted to leave it there, Chair. But I think that's important to recognize that GMT has taken many, many steps for protections here, even if there is a longer time period to develop, specifically due to the leasing obligations, electric infrastructure, as well as HPH timing steps. Thank you.
Follow-up, Commissioner Ackerman?
No, I appreciate that input. Thanks, Ms. Just.
Thank you, Commissioner.
Further questions, Commissioner Oath?
Thank you. And thank you, particularly Mr. Blair, for handling a lot of questions here. I would echo the comments of my fellow commissioners, just acknowledging that this has been a long timeline and that you are juggling a lot of complex issues here between wildlife, electrification, capital issues, et cetera. One of the 2 things that I wanted to explore was similar to Commissioner Cross, particularly around electrification and the timeline, and was going to ask the same question. Is there not a way to do the initial occupation at the North Rim site after electrification and line power is available? So appreciate your answer that you're up against some contractual deadlines there. So my follow-up question on that is there opportunity to amend or extend those contractual obligations? I know you probably saw those coming up and are feeling like it sounds like that needs to happen in the second quarter of 2026. And knowing that you were kind of leading up against this hearing date, I'm curious if you were able to explore that possibility with your contractual obligations.
Yeah, thank you for that question, Commissioner. My understanding is that our ability to extend those deadlines is very limited and would require some hefty payments that are, certainly not preferred over perfecting these leases and contracts through development, which is the intent of those agreements from the beginning. So I don't have a whole lot of detail on each of those obligations, and not typically something I think we would share at a hearing, but I can tell you that we have evaluated those possibilities. Certainly, if we're unable to secure approval in time, we'll have to address that as best we can. But certainly, our plan and our strong preference would be to secure approval and develop under these agreements in this upcoming season once the pronghorn restrictions are lifted.
Okay. Thanks for that. And then I think another issue to balance with kind of this timeline is there's kind of awareness of neighbors. And I want to kind of back up for a moment and acknowledge that even though you did not, none of the requirements to hold a community meeting were triggered here, that you all did hold a community meeting. And I appreciate that and want to call that out and thank you for doing that. And did note that you had a good amount of response, right? You had 7 or 8 folks show up and had some interesting questions, and it sounds like some follow-up meetings occurred. So that's great communication, and I think that goes a long way for folks to understand what's happening. My concern is if we're, there might be some awareness for this first occupation now in 2026, but if we're now talking about second occupations in 2028 and 2029 and into 2030, people's memories are short. Different people may be in the area and interested, have similar questions, and so I'm wondering if you all, in the spirit of what made you be willing to do the community meeting voluntarily this round, would you consider a commitment to doing another community meeting before the second occupations?
Yeah, that's a great question, Commissioner. First, let me just express my my love for that element of the planning and development process. I've been in this industry for almost 30 years. It's hard to imagine that, but engagement with the community, with our stakeholders, with property owners, that's my favorite part of the job, to be honest. So I have no problem committing to additional engagements with our neighbors and ensuring that they're well aware of our upcoming plans. So we've done lots of proactive and voluntary measures along those lines over the years, like sending letters out in advance of upcoming development for folks around a proposed site that we may have spoken to previously, but some time has passed. We have committed to, in the CDPHE BMPs, to hold a meeting post OGDP hearing here prior to drilling so that we can inform folks of the schedule, confirm that what we said previously is still moving forward. And we're happy that we've committed to do that. We plan to do that. And we also plan to put up some public information resources digitally on our website. So with all that, I can say that we're happy to engage our neighbors early and often, and I can commit to personally ensuring that we'll reach out prior to additional future drilling occupations. One thing I think was mentioned in the slide deck as well is the routing of our haul routes for these sites. We've selected those in cooperation with Arapahoe County, and we generally route traffic to the east of this development and then north up to I-70 to get to Market or whatever, to the general oil and gas development area up in Weld County. And so there's not a ton of residents along that haul route rather than going the other direction to the west. And that's all been evaluated by Arapahoe County as part of our local permitting as well.
Great. Well, thank you. Thanks, Mr. Blair. I appreciate that. And yes, I did note that you all were committed to an additional follow-up meeting after the hearing were this to go forward, but I appreciate your willingness to also commit to another community outreach prior to the second occupation. So thanks for that.
All right, other questions for the panel? Commissioner Ackerman?
Thanks, Mr. Chair, and sorry to jump in, Commissioner Messner. I just had a follow-up to Commissioner Oath's line of thought there. And in the initial community meetings, Mr. Blair, Was the schedule presented to them with the 4 separate occupations like it was presented to us today? Or was it the same schedule that was presented early to CPW?
Great question. And I believe the answer is yes. If you give me one moment, I think I can respond, and perhaps Andrea can help me with that as well.
Yes, I can confirm that it was. It was the multiple occupations that was also provided in this PowerPoint as well as to CPW in that email that I referenced.
Thank you. So that's what was provided to the community meetings is the timeline stretching up through Q4 of 2029.
That is correct.
Thank you. Thanks for the additional time, Mr. Chair.
Sure. Commissioner Messner?
Thanks. Just one question. And I might be mistaken, but my understanding is that Arapahoe County as the relevant local government and their regulations have some requirement for electrification of drill rigs. Can you address that?
That is correct. The language of their LDC, of course, is not identical to that of ECMC or CDPHE, but they do have language regarding electrification. We have worked with them on this throughout the process, and they do have an acknowledgement, recognition in that LDC, Local Development Code, that infrastructure must be available for you to utilize it. So they're well aware of our work with Excel and the timing of our operations, and have acknowledged our ability to use a Tier 4 drilling rig in the absence of accessible, available electrical infrastructure.
But haven't acknowledged it in an approval, correct?
Correct. We expect that very shortly. But at the time of this hearing, it has not yet been approved.
Okay, thank you.
And Chair, may I clarify with Mr. Blair one thing?
Yes.
Thank you so much. Mr. Blair, Arapahoe County has received all of the final documentation from GMT for the permit, correct? And we are just waiting on approval. And that contains all of the information regarding the Tier 4 for the first occupation at North Rim, as well as the 3 electric rig usage at the 3 occupations using electric rig usage, correct? And that should be in the final permit.
That is correct. All of our final submission is in their hands. We've even exchanged some executed documents in this process of finalizing the permit. So I anticipate an approval letter at any time. I can't predict the timing, but I expect it very soon.
Great. Thank you so much. Thank you, Chair.
Any final questions? All right, well then I think we need to move into the deliberation phase. We've had questions around the electrification and around the timing and around the CPW consult, and there's been a lot of back and forth on a lot of that. I guess I would just, I'm just recognizing something that at least I recognize from this discussion. There's 2 things happening here, both of which are true. One is there is a great deal of planning involved by GMT to get to the place of coming to us for permit approval. And there's also a lot of evolution in potential plans. And I, for one, am a little disappointed in the evolution not keeping up with the consultation, so that when you come to us, we can make sure that what we're hearing is a rock solid understanding of the application on today's date versus a year ago when they first talked to CPW. That's a little bit disconcerting to me as one commissioner. I throw that out there for other commissioners to think about. I think that generally speaking, this is approvable, but I am disappointed in, again, that sort of evolution of plans not keeping up with consultation and then ending up with, a lot of different typos and other changes, and then having, Commissioner Ackerman have to go through an extensive rehash of how we got to where we are and where we are, where CPW thinks we are. And I appreciate the email. I'm glad you found it. For a while there, I was thinking we needed to continue this to make sure that Mr. Ackerman is comfortable with what you're proposing now. Maybe that's not the case. I'm not sure. So very tentative, deliberative thoughts from me on this. Others? Commissioner Messner and then Commissioner Ackerman.
Thanks, Mr. Chair. I think your comments are accurate, and to me, as the commissioner with expertise in land use planning, this is bad land use planning to have a continual changing application. This is why in land use planning, you have multiple referrals, and at some stage, the application becomes final and can't change before it comes to hearing before the commission. And at that time, all the final referrals happen so that there's clarity with all the referral agencies and entities that what they are commenting on is the final and unchangeable plan. And this one, well, I understand that plans change and plans change in all land use. At some point, the plan has to stop changing, though, before it comes to hearing before us. And it needs to stop changing before the final referrals come, or the final referrals come to the commission for decision making so that they are accurate. And that includes, all the different things that could potentially change in an application, not just timelines, but whether there is or is not going to be electrification, whether there's going to be truck traffic, and the number of truck traffic and the emissions that are associated with the different, equipment that's being proposed, and, how that's being tracked and captured, and the different forms that are, part of an application. And so to me, that ends up being a really important piece of, our review, is that we're reviewing a final clean application, and that all the referral agencies, internal and external, have a final clean application that they're reviewing before it comes to us. So I think that's important. I do acknowledge a lot of the work that's been done on this has been excellent, and a lot of the BMPs that have been proposed are solid. I think the big challenge here is the eternal evolving application. And most of the time when an application evolves, it evolves for the better. And so that's a good thing. Not always, but most of the time. When it comes to the occupations, especially, that is, to me, really important conversation to have solidified. There's nothing in the rules that require this commission to allow multiple occupations, especially if the multiple occupations are primarily based on, financial considerations, which were explicitly removed from the act with the implementation of SB 19-181. And there's lots of, information in the statement of basis and purpose in the rules that document that, including in page 5 and 6. And I won't read that right now, but that certainly was a primary element of SB 19-181 that was removed from the act, was financial considerations or technical considerations. The reason that there's multiple occupations here, as provided by evidence and testimony today, was financial considerations, although I acknowledge that timing stipulations associated with wildlife are an element there. But certainly we see applications on a regular basis that are able to accomplish 24 wells within the timing stipulations that are being considered in this application. There's also nothing that would preclude an operator from providing two separate OGDP applications for two separate operations on the same pad. And I understand that there's a lot of work that goes into an OGDP, but that is a clear path forward for providing two separate occupations, and has steps necessary to ensure some elements of protection of public health, safety, welfare, the environment, and wildlife resources. Because one of the biggest concerns I have with multiple occupations is the evolving landscape that may occur around an application and also an evolving landscape around, updated rules or regulations that may be in place that if it is approved today for a timeline of 4 or 5, 6 years, that it wouldn't, any new rules or regulations that are being implemented wouldn't apply to this particular application as it goes into the second, third, fourth occupation. So one of the things that is a benefit of this application as I look at ever evolving or changing landscapes is the fact that while there are RBUs, just outside of 3,000 feet, that 3,000 feet, best I can tell from the maps and the analysis that I did, really is almost to the border of the state land board land. And so I don't anticipate in this particular application significant changing land uses around this, particularly residential building units or schools or something like that, that would be impacted in a second, third, fourth occupation because of where it's located on the state land board land. In any other circumstance, if there was, if it was, outside of the state land board land, then that would be a different evaluation. But this one does have the benefit of being on the state land board land. I think Commissioner Ackerman brings up a really important piece here, and that, it is important that the referral agencies and CPW in particular are responding to the most accurate information. While I appreciate Ms. Gross's, indication that there is an email out there that may or may not acknowledge that CPW understood the timeline and didn't want to make any further modifications to their consultation. I did look on the record and I don't see anything on the record from that. And so I don't know if I have the confidence today that CPW does understand that and is okay with that or not. It's possible that a continuance might be beneficial. But I'll defer to my other commissioners' thoughts at this point before I make any determination on that. So those are my initial thoughts.
Other commissioners? Commissioner Ackerman?
Thanks, Mr. Chair, and I appreciate the discussion. And I don't think we're any of us at odds here. We recognize the situation here is a bit difficult. My question to the operator when I saw the multiple occupations mentioned that it seems lengthy for 24 wells, even considering the wildlife timing stipulations. And I asked, can you please discuss in detail why this is the shortest timeline possible for the development of this OGDP and bring to light any other contributing factors other than wildlife timing that are contributing to the proposed timeline? Now, full disclosure, they received that question from me yesterday after my consultation with staff. And so they didn't have much time to respond to it. That said, the response to my question was a very brief reference to timing restrictions, equipment restrictions, lease commitments, and limited capital. And I'm disappointed in that response. It doesn't give much detail on why 3 or 4 occupations in an area with HPH, with a discrepancy in understanding by CPW and that's already sensitive to surrounding residents, should receive. I appreciate Commissioner Cross's follow-up questions that brought a bit more to light. That said, I do think that there are a lot of good things with the application, and as articulated by Commissioner Messner and others, and particularly note that the planned, hopefully electric work in the later occupations is very helpful. I would agree with Ms. Jost earlier that multiple occupations is within the scope of our regulations. I would argue, as did Commissioner Messner, that multiple occupations, specifically based upon financial hardship or reasons, the legislative evidence would support that financial reasons shouldn't be taken into account for those purposes. And when it comes down to talking about a continuance, really the only thing causing me to shy away from just saying let's continue this matter so that the operator can work these issues out is a sensitivity to their lease commitments. And I get that that's not our problem. I get that that's on the operator. I also get that we're trying to work together here in a fashion that is very protective in Colorado, but continues to enable the development of energy protective of public health, safety, welfare, the environment, and wildlife resources. And so I'm kind of stuck on two paths here. And one path would be to just say we need to continue so that they can work these issues out. That said, I have significant confidence that they will work this issue out with CPW, at least. The evidence to me suggests that CPW will likely say that it's okay as long as they stay outside the winter timing stipulations. Those are their standard recommendations. With some verification that Ms. Gross mentioned, they sent an email over that concluded the final schedule, and CPW responded that they were okay with that schedule. If we can get a copy of that, or if we already have it in our possession, as it was mentioned, staff may have been copied on that, and that it does indeed acknowledge. If it doesn't specifically and clearly acknowledge requiring a COA with further consultation and follow-up with CPW may be a course of action here that specifically lays forth that schedule and receives verification from CPW. That said, I think an approval is premature to that, but I do think that that's one way to go about this here. It's a conundrum again caused by, I think, the expediency necessary for development for the operator and what I would consider to be not necessarily buttoned up work in this application. So I'm interested to hear from the other commissioners as well. I think there are a couple paths we could go.
Sorry, I'm muted. Commissioner Oath, then Commissioner Cross.
Great, thanks. Actually, I think before I share too many thoughts, I want to acknowledge that I appreciate this discussion and for me has raised a couple of questions that I'd like to meet with our attorneys about, particularly around kind of how the rules address our ability to consider some financial or contractual obligations. So sorry to spring that on everyone, but that would also maybe give some time for the communications with CPW that Commissioner Ackerman was referencing to be provided to us for our review while we are in executive session, if other commissioners are supportive of that.
Commissioner Oath, can I ask a follow-up question that might put you and or AAG Benjamin Boudreau on the spot? Is the question around our consideration of financial, I mean, is that even I mean, like, it seems to me that's pretty self-explanatory and maybe everybody should hear it. But I don't want to, anytime one person wants an executive session, I'm all for it. We will grant it. But I do wonder that because I don't think we take into account financial commitments or contracts or obligations as we go about application of our rules. I don't recall ever seeing that in any of them. But I'm talking out of school probably, and we should probably just go straight into executive session.
Well, I'll defer. If we can address, if everyone's comfortable addressing that in open session, that's fine by me. But I'll leave it up
to you. All right,
AG
Boudreau, you didn't know that this Wednesday morning you were put on the spot. Do you want to slap me around, or do you want to answer the question, or do you want to go into executive session? All of which are perfectly fine.
My advice would be an executive session for us to discuss any sort of, or to have any kind of privileged attorney-client communications, including receiving legal advice.
All right. Commissioner, hold on just a second, Commissioner, Ms. Jost. Let me get Commissioner Cross on the record, and then I'll come back to you. Commissioner Cross?
Thank you, Mr. Chair. And I just wanted to quickly make one point before giving full deliberative comments as well, because if we do go into executive session, I think it would be helpful to provide time to discuss this as well. But one of the things that sticks out to me is with respect to the multiple occupations, I, for one, would also feel more comfortable if there was a COA related to agreeing to the electric production and electric drilling in the future occupations. And so I figured I'd at least throw that out there. So if information is being gathered by the applicant here with respect to the CPW communications, I think it's also appropriate to let them discuss that possible COA and whether they'd be amenable to that as well.
Okay. Now that's on the record. Ms. Jost, did you want to be heard on any or all of the foregoing deliberative thoughts?
Well, I have two points I'd like to say. Thank you, Chair. First off, GMT would be open to a COA that commits to the use of Tier 4 drilling rig for the first occupation at North Rim only, and then the second occupation, the first two occupations at Black Canyon being electric. That is a COA GMT will agree to. Thank you, Commissioner Cross, for bringing that up. The second thing that I guess that I'd like to propose, and Commissioner Ackerman, this would be Commissioner Cross and Commissioner Messner, and Chair Robbins, your comments, is that GMT would also agree to a COA on this permit to meet and consult with CPW after what we're hoping to be an approval today and provide that CPW report to the ECMC. Obviously, ECMC staff would be welcome and invited at that meeting as well. To me, that's just a confirmation of what's already been done by CPW. And then third, Chair, is I have the email that I will send to Mr. Thomas right now, so you guys can have that for purposes of your continued deliberations, if that's okay.
Yeah, that's fine. Do you have an ability to share screen? You could even just do that, and then we could all see it.
I may have to send it first on my share, if that's okay.
Okay, whatever. It's your
Yeah.
case. Commissioner Ackerman?
Thank you, Mr. Chair, and sorry to hop in there, but wanted to focus in on the language that Ms. Jost used there and appreciate that work. Thank you, Ms. Jost. That makes it easier. I recognize that her proposal was that they present to CPW and report back to us on what CPW says. Given the circumstances, my preference would be to obtain CPW's concurrence as part of that COA.
Chair, if I may.
Yes.
Commissioner Ackerman, that's absolutely agreeable.
Okay. All right. With that, I believe we're going to stop deliberations and go into executive session. I would recognize AG Boudreau to help us through that.
Thank you, Mr. Chair. 1 second, please. Pursuant to the open meetings law, the commission is entitled to enter into executive session at this regular meeting to receive legal advice pursuant to Colorado Revised Statutes, section 24-6-402-3A2. During the executive session, the commission will receive legal advice regarding ECMC docket number 250500076. Mr. Chair, you can entertain a motion to enter executive session for the matters and purposes I just named.
So moved. Do we have a second?
Second.
Motion and a second. All those in favor signify by saying aye.
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 Any opposed? We are unanimously moving into executive session for the reasons as articulated by Assistant Attorney General Ben Boudreau. To the folks listening in, there's 64 of you. Thank you for continuing to be patient with us. We're going to go into executive session. That's where we receive legal advice from our Attorney General. We will not take any actions. Once we're done with that executive session, we will return. To do the executive session, we will go into a different Zoom meeting with our Attorney General. So we're going to leave this meeting. We're going to go into the Zoom meeting for e-session, and then we'll come back here. Once we're back here, we will reinitiate deliberations on the docket. That's that question right now. 30, 45 minutes, that's a guess. I do not know exactly how long it'll take. It is 11:10. We also may not come back until after lunch if it is 30, 45 minutes. So the best thing that I can explain to folks listening in is just keep monitoring this channel. And when we're back, what I'll probably do is announce we're back. And then I'll give, maybe take a 5-10 minute break to make sure everybody is ready for us to be back so that we can continue our business before our applicant, our staff, and our stakeholders. So with that, commissioners, I would encourage you to, actually, let's take 5 and then let's go into executive session at 11:15. just to give us a break to do whatever we need to do individually. So we'll see commissioners at 11:15 in executive session. We'll be back here 12, 12:15, 12:30. I don't know, something like that. Thank you very much. All right, it's 12:30 on the 25th of March, and this is the Energy and Carbon Management Commission. We're back in session. We are undertaking docket 250500076, an oil and gas development plan for GMT Exploration Company entitled Gorge OGDP. We are returning from an executive session, and I would recognize Attorney General Benjamin Boudreau to take us through the steps to get back into open session.
Thank you, Mr. Chair. The commission is returning from executive session. During executive session, the commission received legal advice regarding ECMC docket number, one second, 250500076. The commission did not deliberate. No decisions were made. And you can now entertain a motion, Mr. Chair, to exit executive session.
So entertained.
So moved. Second.
Motion and a second to exit executive session. All those in favor signify by saying aye.
Aye.
Any opposed? The motion carries unanimously. Okay. We're in the deliberation stage with commissioners on this front. Before we move further into the deliberations, I would recognize Ms. Jost. I don't know if you chatted with your client or had other thoughts that developed over the last hour or so, but if you wanted to supplement your record with anything before we keep moving forward, let us know.
Yeah, Chair, thank you so much. Really nothing more than we would reiterate that we would be open to a condition of approval regarding the use of the Tier 4 or equivalent rig during the first occupation on the North Rim pad and the electric rig on the 3 subsequent occupations, 1 on North Rim and 2 on Black Canyon. We would also be open to a condition of approval regarding a consultation with Colorado Parks and Wildlife regarding their understanding of the 2 occupations for each pad. And then again, maybe just a clarification for the record that while financials are looked at as every operator's OGDP plans, the priority for the occupations do tie to high priority habitat, the electric infrastructure, and leasing obligations. So thank you, or I'm sorry, contractual obligations regarding a lease, Chair. Thank you so much.
Okay. All right. With that, commissioners, we return to deliberations. We have a couple of issues before us. Commissioner Oath, thanks for nodding to go forward. And maybe if you wanted to focus pertinently on the issue that you had raised, I know we all have lots of thoughts about a lot of things, but maybe having received legal advice, you can help frame it for us and we can move forward.
Yeah, thanks, Mr. Chair. I'm happy to. We'll start out by acknowledging that this one is very difficult for me, and also I tend to, in my deliberative thoughts, kind of cut to the chase of the issue that is kind of I'm hung up on, and I don't do as good of a job as my fellow commissioners at articulating kind of the comprehensiveness of my thinking on these applications and all of the considerations that are at play. So I know that a lot of those things will come out through the course of our deliberations, and want to acknowledge that there are a lot of aspects of this application that are very strong, particularly, it is not in close proximity to homes or schools, and many other aspects. But to frame kind of the issue that is concerning me is with respect to Rule 16. So Rule 16 requires the use of an electric drill rig in this case. And this is an important rule. It's part of this agency's commitment and obligation to address ozone non-attainment. This is a really significant regional issue. And our rules do have an off-ramp that allow for an operator to not comply with this rule in cases where compliance is not practicable. So our rules also include a list of what should be included in an operator's practicability assessment. And while our regs acknowledge that it's not an exhaustive list of considerations, it does include the consideration of looking at the availability of equipment or infrastructure, and then how compliance could be harmful to public health, safety, welfare, the environment, and wildlife resources, how the emission reductions that would be realized through compliance compare with the operational difficulties with compliance, and then other methods that an operator would be taking to avoid impacts to air quality during the ozone season in the event that they are seeking approval under a practicability determination. And these practicability assessments are still fairly new, I guess, in our process. We are continue to develop, clear notion and expectation of what the commission expects to see in order to justify the application of this off-ramp. And I would say, notably, this practicability assessment largely does not include the information in this list. Additionally, it was prepared at a time when the operator had not yet progressed as far in its discussions with the utility provider. So this is kind of goes back to another challenging factor about the evolving nature of this application and kind of the information provided to us not catching up. So, what's on the record in terms of a practicability assessment is not particularly reflective of what the operator is asking for the commission to find here. During testimony today, it was clarified that at this time, the operator has been able to have very productive discussions with the utility provider, and that's encouraging, and is moving towards compliance with this regulatory obligations and has been able to commit to compliance with the rule for 3 of the 4 drilling occupations. So I do acknowledge that. However, the applicant is still asking this commission to determine that it's not practicable for it to comply with this requirement for the first occupation at the North Rim. And the argument that is being made for practicability seems to be solely based on the fact that they want to drill in the second quarter of 2026 because of current contractual obligations. There was also testimony that there may be an ability to extend those contractual obligations, but that those opportunities were not explored because they would be costly. So I acknowledge that the commission has been presented with other practicability assessments and other applications and cases, and in some cases, not all, in some cases has found those to be acceptable and warranted. However, in my mind, a more compelling case has been made in those cases than in this case. I am very much struggling to find that the fact that an operator entered into a contract of their own will, requiring it to drill in a certain time frame, to be sufficient justification for me to find that compliance with our rules that were adopted in order to protect public health, safety, welfare, the environment, and wildlife resources is not practicable, particularly where no attempt has been made to extend those contractual obligations. So that is kind of my framing of the main issue for me. There are certainly other aspects that I think warrant a lot of discussion during these deliberations, particularly around CPW consultation and other aspects, but I'd prefer to let my fellow commissioners with expertise in those various areas weigh in on those first.
Thank you very much for defining the issue and providing some initial thoughts. Commissioner Ackerman, I'm going to pick on you on the CPW and the wildlife issue, if you don't mind me doing that, because I think that was another similar issue that was part of the deliberations to begin with, and maybe you can help do the same thing on that front, as well as whatever else you'd like to say.
Sure can, and that'll be my focus, Mr. Chair. Thank you, and I appreciate the opportunity to do so. I do think, as I mentioned during deliberations, based on my experience, I do think CPW likely is going to be okay with going outside of, or staying with a different time frame, so long as they stay outside of the winter timing restrictions. I'm not always right, but would be surprised if the situation were different. I do see Mr. Moret in the audience now, and will expect that if there's any difference, that he will raise his hand and chime in and say that they do have an issue with that. My understanding, and I don't know, Ms. Jost, if you had an opportunity, or your client had an opportunity to talk with CPW during the break or not, if it's appropriate for you to mention that at this point, and then I'll continue.
Yes, thank you.
Ms. Jost?
Yes, sorry, Chair. Thank you, Commissioner Ackerman. Yes, we did have the opportunity to speak with Mr. Moret, and he also confirmed that he does not have any concerns with respect to the schedule put forth.
Thank you, Ms. Jost. And if that's the case, once again, Mr. Moret's in the audience now, and I'll ask him to speak up if it's any different than as was presented by Ms. Jost there. That said, Mr. Chair, for the record, I do think it's important for the reasons that we articulated beforehand, if we do move forward with this application, to still ask for a COA that requires that we document that point, both with the email chain that was referenced earlier and a specific acknowledgement from CPW that they would be fine with the plan as proposed today from a timing perspective. If those two things are resolved, Mr. Chair, my wildlife concerns are resolved with this application.
Great. Thank you very much. And thank you, Mr. Moret, for rejoining with us and being here. And if you have anything you want to say, raise your hand. Otherwise, we'll take the representation from Ms. Jost and the deliberation from Mr. Ackerman, and we can move on to other issues. So with that, I would look to my other commissioners to see if they have deliberative thoughts on these issues or other issues that are before us. Commissioner Cross.
Thank you, Mr. Chair. A lot of the issues that I wanted to address, I think, have been addressed. I will say that I've become more comfortable with this application, although I admit I've had some heartburn with some of the issues as well. Many of them, as I mentioned, have already been addressed as it comes to kind of this evolving application, some uncertainties as there's been typos, etc. But that said, I think ultimately as I alluded to prior to the executive session, I think I would, one, be more comfortable with a condition of approval that would allow or that would require GMT to use electric drilling and electric production for the future occupations beyond the first one. I do have some heartburn consistent with what Commissioner Oath said about the first occupation. Given what our enhanced systems and practices rules require, it should be something that should be electrified. And so unless practicability shows that it cannot be done so. And here I very much consider this a little bit of a chicken and an egg problem. Obviously there's a lease here that is requiring drilling by a certain time, and utility cannot get electrification in before that time. I think some of my existing heartburn from that issue ties to the fact that there was a comment made by Mr. Blair that you could potentially deal with that timeline through additional payment, although we weren't able to see what the additional financial burden would be, et cetera, for that. And so while our rules don't specifically call for economic feasibility to be a consideration, ultimately we have to provide a BMP or a condition of approval that is going to be reasonable upon the operator. And if we're going to impose something that simply cannot be done or would be so cost prohibitive that it would make the entire project impractical, then even though it's not a specific consideration, that would not be reasonable. And so I think where I kind of sit at this point in time is I, again, have become more comfortable with the first operation being done consistent with what the Reg 7 requirements require for the Tier 4 equivalent, making sure that it's done with the multi-phase takeaway, et cetera, all the other BMPs that would match, with the understanding that the inability to get the utility for electric drilling beforehand is because they have to drill before losing the lease. But again, I think I'd be much more comfortable with the condition of approval for the future occupations to have that electric drilling, which would be required by our ESP rules from the CI rulemaking. And so I think with that, I had some concern with the multiple occupations. I think the fact that CPW has confirmed that they are okay with the multiple occupations, to me, I think that's one of the bigger issues. I agree with Commissioner Messner that I don't think that having multiple occupations should be something that should be looked at lightly. We are in a little bit of a unique situation here because this is state land board land. It's not like there's going to be future housing developments on here by 2029 when some of the additional work is proposed to be done. But that may not be the case with other ones. So I don't want this to be a precedent-setting decision in any way, shape, or form that we're going to have differing thoughts on or similar thoughts on future applications that may propose multiple occupations when a very different situation might exist as well. I also agree with what Commissioner Oath discussed in some of her questions before, and asking Mr. Blair to make sure that continued stakeholder outreach is going to occur. Because as she mentioned, I think beyond just land use changes, there could be different people living within the half-mile range. There could be additional houses built that are still within the half-mile range and people that may not have been aware of everything that's being proposed and going on as well. So I do think that it's important that we continue to have that stakeholder outreach as well. But that said, I don't see anything in our rules that says you can't have multiple occupations. I think it ultimately becomes a question of, will we sufficiently minimize adverse impacts to public health, welfare, safety, environment, and wildlife resources if we have the Tier 4 rig in the first occupation here? We have approved the Tier 4 rig in other situations, so it's not something that jumps out to me as not being protective. Again, I think it really comes down to that practicability here, where obviously our rules, if practicable, require that electric drilling occur. But if it's a situation where they're going to lose their lease, I do find that that is a sufficient reason to require the faster drilling time. And if a faster drilling time is going to be required, and obviously the utility cannot get the capability to electrify a rig in before that time, then I do think that that meets our practicability assessment.
Thank you, Commissioner Cross. Commissioner Messmer.
Thanks. I appreciate all the different commissioners' thoughts on this and the thoroughness in which it was evaluated. And I think that's always a strength of the different viewpoints and expertise on the commission. I've said most of my deliberative thoughts already, but this further evaluation, particularly by Commissioner Oath, has required me to re-review a couple of things. And, ultimately, I think our responsibility here is to apply the rules. The rules are the baseline to ensure protection of public health, safety, welfare, the environment, and wildlife resources. Rule 316C does prescribe specific things that must happen if an oil and gas location is intending to drill between May 1st and September 30th in the ozone non-attainment area. There's also elements in here regarding regarding disproportionately impacted communities that must be met as well. And two of those things haven't been committed to by the applicant. One is 316 4C Romanet 1, which is the operator will use grid power or on-site solar power for all permanent powered production equipment on site, excluding external combustion sources. And also Romanet 2, which is that all drill rig engines and/or turbines with a manufacturer's design rate greater or equal to 50 horsepower will be powered by grid power or non-fossil fuel generated power. In addition, there was produced water storage that wasn't able to, ESP that was in the operator did not commit to. The practicability assessment, however, attempted to only address two out of those three elements. It was my understanding in initially reading the application that the operator had committed to permanent production equipment being electrified by grid power as required by our rules. However, in testimony today, it was indicated that in fact that wasn't a commitment, but rather there was a plan to utilize natural gas engines or some equivalent to that to generate electricity for the production equipment until if and when grid power became available. that could be the case, but there was no mention of that in the practicability assessment or no practicability assessment done on that particular rule requirement. And so that was um, a new piece of information that I gained today at hearing. In addition, I think Commissioner Oath correctly identified the practicability assessment requirement associated with the electrification of the drill rigs. And so applying both the rule requirements associated with the practicability assessment, which are pretty explicit in the rules, and does indicate some additional information could be considered, but at a minimum, needed to address those issues within the rules. I think consideration of a contractual obligation that was fully the responsibility of the operator who entered into it may not meet the bar of reasonable and necessary in my book, as it was testified today that it's reasonably understood that grid power will come to this site. It's more of a timing of exactly when. And so I struggle a little bit with that one, as, like I said, the rules are the baseline to ensure protection of public health, safety, welfare, the environment, and wildlife resources. In promulgating the rules around enhanced systems and practices, we were relatively explicit as to what was going to be required in what situations. And while we provided off-ramp, the off-ramp also was explicit as far as what was required. And at least one out of the three items that were required to have a practicability assessment wasn't done. And one of the practicability assessment pieces hinged primarily on contractual or financial issues rather than the lack of grid availability. So those are my deliberative thoughts and my analysis of the application of the rules. I do agree with Commissioner Ackerman that while I think a condition of approval is appropriate for the wildlife timing and whether or not Mr. Moret did understand the calendar that was associated with this, the schedule. I think Mr. Moret has indicated that he's okay with it as indicated. So,
All right, thank you, Commissioner Messner. I too will follow Commissioner Oath's lead in that I jumped kind of straight to the issues that I see before us, and I'm comfortable with the CPW and the wildlife issue. I think that's sufficiently been dealt with. I think a COA there makes some sense. I continue to struggle with the issue that Commissioner Oath raised in terms of the practicability assessment, in this case, not necessarily addressing the items contained within Rules 316, availability of equipment and infra, the compliance with public health, safety, welfare, reductions of emissions versus compliance. It really did turn, from what I could tell from the testimony, on the contract and the contract potentially costing more. And I'm still struggling with whether that's sufficient justification for this. I'm not as concerned about the DIC because this is on state land board land, and while it may be near or in DIC, there's not people nearby. There's no residential building units. And I appreciated your point, Commissioner Messner, earlier. Even if this is a two-pronged designation, there's not going to be some because this is state land board land, and that differentiates this application quite a bit from other applications that we see before us that are subject to development pressures from local governments and et cetera. I think, and so I appreciated some of the points you made there, Commissioner Messner, as well. But I also appreciate that this application has a lot of strength to it. There's a lot of good things to this application, as articulated by the applicant in their summary of the issues that are before us. I think what I'd like to see, and I hate punting, but I'd like to potentially give the applicant another shot at the practicability assessment to further flesh out the provisions of Rule 316 and also to further potentially come to the commission and explain further the contractual issues. And I would note to Ms. Jost and the applicant that there are opportunities for us to gain that information as trade secret or in an executive session so that we can make sure we're making the right decision for the state of Colorado without infringing upon trade secret or financial information that is proprietary to the applicant. So I would perhaps ask AG Boudreau to arise if that idea is something that other commissioners are interested in. So just stand by, because I don't know where other commissioners are going. Commissioner Cross, and then
Thank you,
Commissioner
Mr. Chair.
Messner.
As I said, I have felt more comfortable in the application, but I still do have a little bit of heartburn because obviously we can't make a purely financial decision here, but if it's something that is so cost prohibitive, it makes it impossible for the applicant. That makes it not reasonable as well. So I would appreciate additional information with respect to what you're asking.
Commissioner Messner. Thank you, Commissioner Cross.
Thanks, Mr. Chair. I think what you're suggesting is a continuance in order to get additional information specific to the contracts and to be able to resubmit the practicability assessment that further fleshes out whether or not the required ESPs and the rules are practicable or not. And I have no problem with that. I think that's a logical point forward. I would also ask the operator, as we continue this, to look at whether or not it is feasible to be able to comply with the enhanced systems and practices rather than go down the rabbit hole of having to do a practicability on 2 out of the 3 things. The one that I'm actually, funny enough, concerned about most right now is the lack of commitment to the grid power of all permanent production equipment that wasn't addressed in the practicability assessment, and would hope that that came to us not as a practicability assessment, but as a commitment to ensure grid power to all permanent production facilities, in addition to the electric drill rig, whether you choose to move forward with a practicability assessment that fully addresses the elements in the rules, or find a way to electrify that and commit to the enhanced systems and practices. I obviously leave it to the applicant to decide which path they would like to argue.
Commissioner Cross. Thanks,
Thank you,
Commissioner
Mr. Chair. I wanted to raise one additional thought consistent with what Commissioner Messner is raising, and perhaps we could consider an additional COA as we've done similar applications, whether it be for gas capture plans, et cetera, to what if Xcel's energy line to the production facility is not ready at the time production would begin, have production shut in, the wells shut in until such time as the production facility is electrified.
Okay, let's put that in our back pocket over in the corner. Let's see where the other commissioners are in terms of next steps. Commissioner Ackerman.
Thanks, Mr. Chair. And I do think this is a good way to approach this. I don't think that while, we have this discussion, or at least I consider whether to approve or deny an application as it's put before us, I do try to approach things from a reasonable perspective. And there are some opportunities here to discuss denial. I don't personally think that's the right way to go. I agree with an opportunity for the applicant to cure, for lack of a better word here. I do want to also state that I was the one that raised the question with the operator initially about the lengthy multiple occupations, and I do think that in the end, it's something that we may have to kind of keep a close eye on going forward. As was stated, there's nothing in our regulations that currently prohibits multiple occupations, and that we do need to follow best management practices to protect public health, safety, welfare, the environment, wildlife resources if we do choose to go down that road. I want the listening public to know that that's something I'm keeping a very close eye on. It's not something that I would intend for, and particularly for the reasons articulated by Commissioner Messner, that land use changes occur in most situations. Now, that said, again, I won't reiterate what was said about this being on state land board, but it is a bit of a unique situation. To Commissioner O's point, I do think when we passed the practicability assessment, the intent here was to do our best to protect the ozone non-attainment area and really allow for an exception when it was just very reasonable that there needed to be an exception. To me, what we have here is kind of justification for an exception that's somewhere beyond that we have to determine whether or not that meets the scope of our regulations and the intent of our regulations as well. And so to me, that requires, significant effort and significant answering of at least the questions that are asked in the practicability assessment regulations, but even going further than that and specifically talking about the reason, which is why I asked for details about the time frame here. I think that it's necessary to really make a case to justify significantly why that exception needs to happen, not just say, it's not working out for us for this and then move on to the next paragraph. I don't think that was our intent. And so I do like the opportunity for the operator here to really dig into a practicability assessment. Now, that said, I also agree with Commissioner Cross's comments that I do keep in mind the necessary and reasonable nature of what we're doing here. And that's the difficulty of our job here, is that there is a judgment call in there somewhere as to whether or not is it reasonable and necessary to forego protections in the non-attainment area for the practicability assessment reasons, or does it not become reasonable and necessary because those reasons don't rise to that level? And I think that in order to make that judgment, we need significant information included in that practicability assessment to be able to make a proper judgment. And so I'm comfortable, Mr. Chair, with your stated path forward.
All right. Thank you for those articulated reasons. You did a better job than me of explaining why. Commissioner Oath, did you want to weigh in with anything?
Yeah, sure. I'm just would say, as I indicated earlier, I don't find the practicability assessment that was provided to be compelling, but I'm certainly amenable to allowing for additional information to come forward for us to evaluate.
All right. Ms. Jost, do you want to provide any reply statements, response to what you've heard from commissioners at this point in time?
Yes, thank you, Chair. GMT will, if it seems to where this is going, would request a continuance for 1 week until April 1st and will provide an updated practicability assessment based upon your comments today for additional review by this commission.
If
that's open to you, Chair, and the commissioners.
It would be open, I think, contingent on if you want to be heard again in a week, how quickly will this turn for commissioners to be able to adequately have time to review the updated information?
Yeah, we would aim to have this submitted by Friday close of business.
Okay, so that gives us Monday, Tuesday.
Mr. Chair.
Yeah.
Not that it is necessary for me to be there, but that is a scheduled time off that I have next week. In addition, if I remember the docket for next week, it already has 3 OGDPs on the docket and could be full, but so that may be something to look at. I understand the need for expediency, and so
sure.
This does not have to hang on me, but I did want to acknowledge that.
All right. 2 questions. In hearings, Manager Thomas, can you talk to me about the docket for next April 1st?
Yes, of course. Commissioner Mesner is correct on April 1st. We do currently have 3 OGDPs scheduled for hearing. It's tough to gauge how much time 3 will take, as well as the deliberations on this, but that is what we have scheduled. So that is an accurate statement. The following week would be the rulemaking for HPH maps, as well as a contested OGDP hearing. So the schedule does not get any less tight, so to speak.
All right. The other opportunity could be to find a Thursday or a Friday morning or a Monday or a Tuesday morning for just a special meeting on this. So maybe what we should do is continue it to April 8th. But the applicant and the hearings manager are encouraged to, well, how do we do that, AAG Boudreau? What I'm trying to do is like have a firm date, but be able to see if we can find an earlier date for a special meeting. Is that doable under public notice requirements?
So the idea is to say we're going to do this April 8th unless the applicant gets the requested materials in earlier and then schedules something.
No.
Okay.
It's we're going to continue this to a date between now and April 8th at the latest. But I'm trying to look at calendars and schedules right now, which we could do, I guess, if we wanted to do that. And see if there's a time on the 6th or the 7th or on the 2nd or the 3rd. I'm happy to look at calendars. So, Hearings Manager Thomas, what's your pleasure?
Mr. Chair, might I suggest a continuance pending further order? In the interim, I will not to go beyond April 8th. And in the interim, I will poll the commissioners for availability, provide any dates that are open to the applicant, and we can try and find a time that works for everyone to do this matter, to hear this matter again. And that way we can do that offline, and I can get the dates to the applicant as soon as I hear from the commissioners on their schedules.
All right, Ms. Jost, we're making sausage here, and I apologize. I do not like doing that in an open record, but it is what it is. Do you have thoughts about this latest gambit here?
I would agree with Mr. Thomas that if we have no later than April 8th and we submit the practicability assessment, updated practicability assessment by this Friday close of business, and we have the ability to potentially have a hearing prior to April 8th, that is fine from our standpoint, from GMT's standpoint. And we greatly appreciate that. I think everyone understands the need for a turnaround.
Yeah.
And so I think we greatly appreciate the April 8th being the last time. The last date, I guess I should say.
Okay, AAG Boudreau, do you want to turn that into a motion, or can I say so moved?
I'll recommend a motion if that's okay.
Go ahead.
I'd recommend a motion to continue this matter with instruction to the applicant to submit documentation and information consistent with the commissioner's deliberations upon returning from executive session, and that the date will be set by ECMC's hearings unit in conjunction with both the operator and the commissioners to find a date that is mutually agreeable.
And no later than April 8th.
And no later than April 8th.
Ms. Jost, is that acceptable?
Yes, thank you, Chair. Thank you, Mr. Boudreau.
All right. I'll move that motion. Do we have a second? And then I'm going to ask for further questions.
Second.
All right, we have a motion and a second that's properly before us. Is there further questions, comments, deliberations on the motion before we take a vote? All right. Well, once again, I would just point out that I think this is indicative of the time, effort, and merit that applicants spend getting stuff before us, and that our staff spends reviewing it, and that commissioners spend on the dais trying to ensure that if oil and gas development plans are approved, they're consistent with our rules and regulations. So with that, I would call for a all those in favor signify by saying aye.
Aye.
Aye. Any opposed? That motion carries. All right, Ms. Jost, we will see you sometime next week or the following week through April 8th. Please work with Hearings Manager Elias and your clients, and commissioners be ready to get pinged by Elias for dates that you might be available as well.
Thank you, everyone.
All right, thank you. All right, I think that concludes the business before the commission agenda today. Do we have a motion to adjourn?
So moved.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Aye. We are adjourned. We'll see you sometime real soon.